Welcome back to Chokijebo Media. I want to take us through what we do every day that we never take care of. Important stuff we need to take care of. Discussing it will take 3 parts, and I'm doing this courtesy of United Capital PLC and its professional experts. In their webinar I attended last week, and I believe it's going to be beneficial for every one of us to know. It is important, and the topic is next of kin versus beneficiary. Let's watch it together and learn more. How to take care of our estates.
Welcome to today's webinar themed Next of Kin versus Beneficiary, Understanding the Value of Estate Planning. This is brought to you by United Capital Trustees, a subsidiary of United Capital Group. Now, my name is Florence Echandu, Communications Officer here at United Capital Group, and it is indeed an honor to serve as your moderator for today. Now, coming up right on the webinar today, we'll have the pleasure of listening to industry experts shed the light on the theme Next of Kin versus Beneficiary. We'll be discussing the differences, the similarities, the role of trust and why we should incorporate them in estate planning, government policies, and so much more. So I enjoin you to grab your notepads, grab your pens, sit back, relax, and let's get right into it. Now, just before we begin, we have a few housekeeping guidelines. Now, this session is in listen-only mode. So should you have any questions, we'll have a question and answer segment later on in the session where our speakers can address every single question you have. For our Zoom audience, please submit your questions via the Q&A section or the chat box. It is located at the bottom of your screen. And for those joining us on YouTube, please use the comment section. And also, please note that this session is being recorded and the recording will be made available to you after the webinar. So as we all know, the world is a global village, right? And we would like to do a quick roll call. So please, in the comment section, you can start by dropping wherever it is you're joining us from. Please just drop the comments. So we'd like to acknowledge where you're joining us from. Right now, I would like to kick off by introducing our esteemed speakers for today. First on the list, we have Dr. Sophia Abiri Franklin. She's the managing partner at Georgetown Solicitors. Dr. Sophia is also an expert in succession planning, women inclusion, corporate and individual sustainability, and so much more. Thank you very much for joining us, Dr. Sophia. You're welcome.
Thank you.
Thank you very much, Dr. Sophia. Up next, we have Michael Abiodun Thomas, who's the Managing Director and Chief Executive Officer, United Capital Trustees, our host for this webinar. And here at United Capital Trustees, Michael leads business strategy, operations, and development across the various trust services. Now, his areas of expertise span trusteeship, wealth management, finance, law, and corporate trusteeship, and so much more. Thank you so much for joining us, Michael.
Thank you, Florence, and good morning, everyone.
Good morning once again. And finally, we have Nnamdi Okeke, who's the team lead private trust at United Capital Trustees. Now, Nnamdi is also an expert in private and corporate trusteeship, family office management, dispute resolution, and so much more. Thank you for joining us, Nnamdi.
Thank you very much, Florence. Good morning, everyone.
Good morning once again. All right, then let's get right into it and we'll begin with Michael. So usually the terms next of kin and beneficiary are often misunderstood and used interchangeably, right? Despite the fact that they have different legal meanings. So could you explain the differences between these two designations and the role they play in estate planning? Thank you very much.
All right, thank you so much, Florence. And once again, yes, indeed, these terms are used loosely and sometimes interchangeably, right? A next of kin is generally any person who is, close to you. It could be a relative. It could also be a legal relative, like a friend, a neighbor. Generally, their role is to enable them make decisions on your behalf or the first point of contact. So you will observe that in workplaces, we do have forms we fill when you're applying for a visa. There are different times when you're asked to include the next of kin and their contact. The main purpose is so that these ones can be reached and where you are indisposed. And again, this permeates. However, a next of kin is not necessarily a beneficiary. Why a next of kin can manage an asset or anything that is due to you, they will not necessarily automatically translate into beneficiary. A beneficiary is someone who is expressly and explicitly stated in a legal document as someone who derives benefits from any assets that is accruing to you. And those kind of things have to be intentional. So when someone is not stated, because someone said, oh, who is a beneficiary? And they said, no, I have a next of kin. I mentioned someone as a next of kin, except that next of kin in a legal document, either in a trust or under a will or under some intestate law, is stated as your beneficiary. A next of kin does not automatically translate. Also, a next of kin has some responsibilities that come with it, because sometimes the person may be required to take a decision for you where that the subject is indisposed, and that person will also have to carry out certain things that is required on your behalf in the stead. However, a beneficiary primarily just takes benefits, of whatever is in the estate as being specified and distributed by the testator or the settlor, as the case may be. This is a simple, easy to understand next of kin difference from a beneficiary. Thank you.
All right, thank you very much, Michael, for clearly defining the terms next of kin and beneficiary. Right. So now that you have laid down this foundation, our topic this morning, our team this morning says next of kin versus beneficiary, understanding the value of estate planning. Now, so we'd like to set the foundation for what exactly estate planning is. So could you help us paint a clearer picture of estate planning and why it is considered such an essential element of financial planning?
Thank you again. So yes, again, estate planning typically talks about the different kinds of vehicles and tools by which you can adequately preserve and have your assets distributed to your loved ones and specifically your beneficiary. And these are tools that can be used across board over a period of time. Again, the primary reason is this. Under your financial journey, at a certain point in time, you're acquiring assets, you're increasing on assets. As you get older and as you begin to have dependents and loved ones around you, you're also making plans for them. Now, except those plans are made intentionally by i.e. by a testamentary will, by a trust, by some other vehicle, by power of attorney, by a deed of gifting, your asset will automatically go interstate, right? If the person passes on or any other thing happens, there's a possible demise, then that means that your asset will be distributed according to the laws of the state you are resident or domicile in. Now, an estate plan allows you to utilize any of the tools under it to specifically and intentionally determine how your asset will be distributed, whether it is in your lifetime, as in the case of a trust, or it is upon demise, as under a will. And there are no ambiguities, which allows for the benefit. Apart from the tax benefit, it allows for peace of mind. It allows for zero to lead to or no litigation in the terms of how it is being distributed. It also allows for the protections of minor. People have some dependents who are minors, and you want to be able to cater and to prepare for them. We have seen several instances in this practice where the breadwinner or perhaps the testator passes on, or someone dies interstate and there's no defined will. The family wrangling, the uncertainty that is occasioned from this, the helplessness of the dependents, like the children and the spouse of the deceased person, is actually unbelievable. So we tell people, you're smart, you're educated, you work this hard, please preserve your assets, preserve your legacy, and be intentional about how you distribute your asset. That is the only way you can protect your loved ones. Thank you.
All right, thank you very much, Michael, for clearly defining that to us. In a nutshell, basically, you have mentioned the fact that in order for your beneficiaries to have peace of mind when you are no longer with them, it would be advisable you plan an estate. Thank you so much. So let's bring it back home to Nigeria. Now, here in Nigeria, most times when you hear conversations about inheritance and death, nobody wants to talk about it, as it's often seen as a taboo. I mean, nobody really wants to die, but everybody would love to inherit assets, which could be money, real estate, cars, or whatever. So please, I'm taking it over now to Dr. Sophia. Do you think this cultural mindset would hinder the widespread adoption of estate planning? And what challenges or misconceptions have you observed, and how can we shift this attitude in our climate? Over to you, Dr. Sophia.
Yes, thank you very much, Florence. Indeed, there is a misconception when it comes to the issue of estate planning. And I'm trying to broach a conversation with a client or a random friend, and you're talking about debt. The average response is like exactly as you said, God forbid, it's not my portion. You know, that kind of thing. And it's not supposed to be like that. Instead, the thought of planning your estate should empower you, should empower an individual. I've had very experience when it comes to this issue of estate planning. And so recently, some crop of clients I find are interested are very young. They are in their 30s and coming out to say, look, I want to plan my estate. I'm thinking about trust for my daughter. And then the crop of people you think should welcome the idea are not responsive. People average between their 50s, 60s, and shockingly, from my experience, it's even the educated audience that are not embracing the idea of estate planning. You find that most people that you feel are educated that would easily jump on the idea are kind of adverse to the issue of estate planning. I don't know why. Another issue I found out there for those that are educated, that are real high network individuals, they have the issue with putting their assets together. So I don't know if it has to do with our laws and the way things are this end in Nigeria, where people acquire assets without properly documenting them. And so I've had experiences with various clients where we're trying to discuss estate planning, and it's taking months for the individual to gather a list of his estate, properties. He has so many lands out there that are in choice areas but are not properly documented. And then even for the religious setting, you know, there's so many scriptures in the Bible that says, oh, who live and not die. And so I don't know if there's this thing about the religion that hampers the thought of people to sit down to plan their estate. Conversely, there's also a portion in the Bible that says that a man should actually put his house in order. And so that should sway for those that are the Christian audience to think about it critically, because the thought of planning an estate should actually empower the individual, that you have the power to designate who and who among the beneficiaries should have what. Like Michael has said, the negative aspect of not planning an estate would mean that your asset will devolve to those that you might not even want to get the assets in the first place.
Then thank you very much, Dr. Sophia. Thank you so much for sharing. I mean, you have mentioned the fact that a lot of people who are even in tune with planning their estates right now are actually young people. And it's really beautiful to see that the mindset is actually shifting. And like you mentioned, there's really no age limit to estate planning. As your assets are growing, you should start planning an estate so that your loved ones and beneficiaries are not left hanging when the time comes. Now, let's take it over to wills, right? Wills are a fundamental component in estate planning. So from a legal perspective, can you walk us through the process of retrieving your assets, especially in a case where there are no wills in place?
Wow. Okay. When there are no will in place, mean the deceased, someone has died intestate, that means he did not write a will. It's not that easy, because when you talk about retrieving assets, one of the first things that come to your mind is in identifying the assets. And you know how we are in our culture. We are very secretive. You have situations whereby a couple is living together and the spouse does not know exactly what assets the husband has. Or even the wife may have certain assets We have situations where you find that a woman is building, has projects, and the husband does not know. And so we're talking about retrieving assets. I'm talking about real properties. That's an issue, because if you cannot identify the asset, how can you retrieve? And then the next thing you talk about, when we talk about assets, it's good to clarify what assets is. So it's not just building. You talk about money in the bank, your shares, your stocks, investments, whatever beneficiary of any investments you have anywhere within the country, outside the country. And so you might want to start with the state where you are. For instance, let's start with Lagos, where we are speaking from now. The process is a bit cumbersome. Yes, the Lagos Administration of Estates Law has designated what to do. If you look at it, it sounds very easy, but in practice, the earliest one can get in terms of duration will be about 6 months. And that 6 months, you would have been on your toes and you have all your acts together. The first thing that you do, you have to obtain the death certificate. And the death certificate will have to come from the National Population Commission. So you get that death certificate, and then it brings us to the next issue, who will be the administrators. Of course, the law says, the law has prioritized the people that can apply, which basically will be the next of kin. Section 49 of that law says, prioritizes the next of kin to be the spouse, the children, the parents of the deceased, and then the siblings, in that order. So when I list those names, you have some things start playing in your mind. Talking about retrieval of assets, we had an interesting case a few years ago, whereby the deceased died, and then the mother was trying to get part of the estate, and the wife was also trying to get part of the estate. Of course, the children are there. In this case, they were minor. And you'll be wondering, of course, both of them are legally ripe to apply for that estate. And so these are the kind of things you will not want if you are here in this call, to avoid a situation where a death would lead to an issue between a mother-in-law and a daughter-in-law, just because monies and assets were missed in the deceased estate. So the process is cumbersome. And one thing to note in retrieval of assets where there is no will is the fact that after you succeed in listing the asset, it will be valued. There's a segment in the probate where your assets will be valued, typically an average of 10%. Now, 10% of an asset may look small when you hear the figure, but look at this situation. Recently, we had another situation where we were processing the letter of administration for a particular asset. And then the tax was assessed to be paid on this asset was 17 million, about 17 million. And this is a widow that the husband died and left a huge property for, no money in the bank. They just needed to do transaction with that property, and then they cannot even sell. In the process of getting the rights to be able to transact with that property, they have to cough out 17 million. We are in the process of applying for a variation to the CJ. But even if that goes through, how many people can afford that, to afford the process? Another thing you need to note is that you're also taxed for your chattels, which will probably still be another 5 or 10%. So in the process, there might be mixes here and there. Assets might get lost, because if you're not able to identify the asset, you can't bring it to probate. And if you cannot bring that asset will just be dormant there, can be lost. Someone can be using that asset without permission, and even the so-called beneficiaries can as well lost out. Another thing to note, aside the duration, is the potential conflict that can come, and the hardship this process of retrieval can actually give. At the end of the day, you can actually get your assets retrieved by the letter of administration process in probate, which takes time. You get your shorties. There'll be a newspaper publication, which takes about 21 days by law, but in practice, we give it about 1 month. So this is a situation whereby when the newspaper publication is done, it's taken that the notice is made to the public about the probate. And so anybody that has interest will come. One thing you will note here is the issue of privacy. I think some few years ago, in the course of processing a probate, a very renowned clergy passed on. And when we went there, while looking at the newspaper publication, we saw the name and we're like, oh, you mean this person with all the clouds and knowledge, this person did not write a will? And so that's one thing, because it also shapes the perception. Estate planning in itself should be seen as something that should actually brand you to say you are together, you're well-rounded, you have planned your life, you planned your career, you have a business. You should also be able to put your house together, plan whatever plans you want to go with. Is it trust? Is it wills? Plan your insurance, plan your life very well, so that at your demise, your brothers, your sisters, we've seen situations whereby even children are longer ahead. We're talking about retrieval of assets. One final story that might interest you is a matter we are dealing with that finally landed in mediation. The deceased is a clergy. That means like a reverend father. So he has a family, and then remember that he has sworn an oath of allegiance to the church. So we are talking about religion, we're talking about law. This other set of people feel that they are entitled by virtue of the fact that he had pledged everything to them. The family, which is the siblings, felt that they are entitled. Of course, the law says Section 49 prioritizes siblings and the family. Of course, we went to court, which landed in mediation. We came to a middle ground, whereby the church people will have some part of the assets, and then the family people will have. That's how we are doing this. But if you look at all those things that will come to play while retrieving your asset, one question to ask is, when you pass, do you want to pass your loved ones through this stress, then the trauma, and then the situation where the next of kin do not even know the asset? That is another issue where they have to go through banks, companies to go and ask, I want to find out, can you check? It's a whole long process. So even if it's something that is doable, it's not advisable to plan to go through that route. Thank you.
Thank you so much, Dr. Sophia, for clarifying the fact that assets are not just limited to money and real estate. I mean, it could be shares, it could be investments, it could even be stocks, it could be anything. Well, I also like the fact that you painted the scenario with family members. And like you mentioned, it's always advisable to plan your estate properly. As your assets are growing, you plan your estate properly so you can avoid any sort of conflict between loved ones when you are no one. Also ensure that there's privacy for your family. Now let's take it over to, let's talk about wills, right? Michael, could you expand on wills? What exactly does it take to process one? Like, can you simplify the process of getting a will and also the process of asset distribution? What are the steps that we can take to ensure that our loved ones are being taken care of when we are no more? Thank you very much.
Right, thank you so much. And yes, so generally, what a will does in terms of being able to simplify the asset distribution process is that a will generally is considered a legal document which allows you to put together how you want your assets to be distributed through specifically named beneficiaries. And because we say a will is ambulatory, it takes effect only upon the demise of the testator. The testator is the one who writes the will, right? And the beneficiaries are his dependents who take benefit from the will which is accrued to. The subject of it are his assets. And as Dr. Sophia mentioned earlier, asset costs through a wide range of many things, whether it's real estate, money in the account, equities, intellectual properties like patents, like trademarks, jewelries, physical belonging, cars. All of these things are assets that should be specified. And oftentimes when you draw up a will, you want to be able to ensure that those wills, all those things are detailed down. Who can make a will? Anyone who is of a sound mind, who's an adult, right? Once you're 18 years old or 21 in Nigeria, you're an adult and you're capable of making one. The law also requires that whoever is making that is deemed to be in a sound mind. You have, you're in your sound mind. You're not insane. You're not mentally derailed. You know what you're doing. And those are things that those are things that you may want to specify towards that. Intention is also very clear in terms of how you want your will. We had an instance where a client had mentioned what he wanted done with what will deem a family business, and the intentions did not sort of align with perhaps what you think that the immediate family would think, but those are his express intentions for it. And that is one of the benefit of how a will is being distributed, because intentions are very, very clear. A will is also typically signed, right? And it's also signed in the presence of at least two adult witnesses. And why are you doing that? You're doing that by saying that when you're signing a will, there are two adults who can see that you actually signed this will, and there were witnesses to that, and they have a portion where they witness. Please note that the witnesses are not required to look at the content of your will because they are private, but they are just there to witness that they saw you make this will. We go the extra mile by doing photographs, even having a video recording of the testator signing as an overwhelming evidence in the event that anyone could see that. And it must also show that that person who made the will did not do it under undue influence, right? You were not coerced. You didn't have someone put a gun or a knife to your head and said, please write this will or see how it would. Proper execution is also required. Now, how does a will simplify the distribution process? Because of these processes, it's made a will very clear. The instructions are specific. Number two is that it also allows for the appointment of an executor. An executor is a trusted person who is appointed to oversee the administration of the estate and the distribution by the time the will is read in court.
Hope you've learned something new. You've got some new changes, new idea. Now, let's go to the part 2. Don't forget to subscribe to my channel. This is Chokitibu Media. Thank you so much. See you